This is the podcast of the Nova Center on Business, Human Rights and the Environment. Welcome.
Welcome to the podcast of the Nova Center on Business, Human Rights and the Environment. My name is Luís Prata Castro and I will be the research associate assisting on this episode. This is our third episode on the perspectives on the Omnibus Proposal, and now we'll pass the floor to our founder and director, Professor Claire Bright.
Thank you so much, Luís. And I'm here today with Cannelle Lavite, who is the director of the Business and Human Rights program with the European Center for Constitutional and Human Rights, as well as Nicolas Bueno, who is professor of international and European law at UniDistance Suisse. Thank you, Cannelle, and thank you, Nicolas, for taking the time to be with us today and sharing your perspectives on this third episode on the perspectives on the European Commission's Omnibus Proposal. We will focus more specifically on the issue of civil liability and access to justice for right holders. So I would like to start maybe with you, Nicolas, if that's all right, with a couple of background questions. And perhaps it would be helpful for our audience if you could tell us a little bit about the enforcement mechanisms that are in place under the Corporate Sustainability Due Diligence Directive as adopted in 2024.
Yes, hello, Claire. Thank you for the invitation and the questions. So basically, there are two main enforcement mechanisms in the CSDDD. We have a public enforcement and a civil liability provision. The public enforcement clause aims at establishing public authorities that will be empowered to conduct investigations and, in the worst case, to impose some financial penalties on the large companies that have failed to conduct their due diligence. Basically, the CSDDD have other rules on these public authorities regarding the financial penalties. So when one of the rules is that when member states will introduce these financial penalties, the maximal fines must be at least 5% of the world turnover of the company. So this public enforcement mechanism is more based on the German law that is already existing and have been adopted in 2021. The second mechanism of enforcement is the civil liability provision. This is currently in Article 29 of the CSDDD. And this civil liability, it aims to ensure that affected individuals who have suffered a damage from the company, for example, a community impacted by water pollution due to a mining company, can ask for remedies against the large company that is covered by the CSDDD. In fact, it should seem obvious that an affected individual could be able to ask for financial compensation, but in practice, this can be extremely complex without a provision clarifying that a parent company has an obligation to conduct due diligence to avoid this type of damage. So basically, these are the two mechanisms of enforcement that we have in the CSDDD. One, public enforcement, in which public authorities will conduct investigation and, in the worst case, fine a company. And the second, where the individual or the affected individuals can directly go to a court through these mechanisms of the civil liability.
Thank you so much, Nicolas, for that very clear explanation. And sort of following up on that, I would like to ask you, but also I would love to hear Cannelle's opinion on that afterwards. Why are enforcement mechanisms important in the first place in a law like the CSDDD?
Well, I believe that for many years, large companies have pretended that they were already enforcing, that they were already having in place processes implementing the UN guiding principles on business and human rights internally, and that these kind of enforcement mechanisms were not necessary. So the idea or the narrative of many companies were they're saying that we are already doing it, we don't need any mandatory obligation. regarding the implementation of the UN Guiding Principles on Business and Human Rights. And why these mechanisms of enforcement as established in the law are important is first maybe because this was not the case, that in fact companies were establishing already having this mechanism in place. A study, for example, in Germany in 2020 under Angela Merkel showed that only about 22% of the companies could really prove that they had adequate processes of due diligence already in place. So the first argument, or the first part of the answer, why this enforcement mechanism is important is really to ensure that due diligence will be really made in practice and conduct and carried out in practice. The second part of the answer is maybe to level the playing field between all actors, because many companies, or we see the 22% of the companies here in the studies in Germany, have already in place good and adequate due diligence processes. So for them, it is a bit unfair, or it's not really encouraging them to continue carrying out these processes as required and is expected by the UN Guiding Principles on Business and Human Rights, when they see that other companies can simply don't apply these due diligence processes internally without any possibility of enforcing this failure of conducting the due diligence obligation. So I think these are the two part of the answers. The first, to ensure that most companies or all companies enforce their due diligence. And the second, to level the playing field with the companies that already have mechanisms in place.
So my second question is about, and it sort of leads on to what Nicolas was just saying, why are enforcement mechanisms important in the first place? And what are the lessons learned that we can see from the example of Germany, for example, with the German Supply Chain Due Diligence Act? And I'd like to give that question to Cannelle, please.
Yes, thank you very much for this invitation. Just to add very briefly on what Nicolas has just said, I think the reason why we want to make sure that those companies enforce their human rights due diligence is also because we want to avoid damages in the first place, right? I mean, this is all about prevention. And rights holders, they want to ensure there is no damage, because some of these damages are irreparable. But it's also in the interest of those companies to ensure that they do not incur the risk of civil liability later on, which is a much bigger risk than simply having to implement a thorough and in concreto human rights due diligence process. And in terms of concrete lessons learned from the work that many of my colleagues at ECCHR have been doing on litigating cases under the German supply chain law, when we talk about meaningful enforcement, I think we should talk about what the Omnibus is now trying to introduce. And this is this notion of direct or indirect commercial partners. So what we've seen in the cases that we've worked on is that the German supply chain law is also integrating this notion of limitation of the duty to tier 1 suppliers and business partners, with the exception of when substantiated knowledge can be brought to a company that violations are also happening beyond their tier 1. And this in concrete has led to overwhelming of small and middle enterprises who ended up receiving a lot of meaningless, in the sense of very abstract, questionnaires that were aiming at understanding through a tick-the-box approach the risks entailed in their activities, in their tier 1 activities. And this is actually funny, not in a nice sense, because the very claim of the Omnibus, is to bring simplification. But actually, we can see that if enforcement focuses on tier 1, it leads to the overwhelming of companies who are faced with very abstract obligations. But we have seen that in our cases, actually, the substantiated knowledge was characterized very broadly in the 6 cases that we have filed, whether on forced labor in China with regards to the Uyghur minorities and the automobile sector, whether on banana Guatemala plantations linked to German supermarkets and serious labor rights violations. So I think there is also a question of legal certainty and how enforcement mechanisms can also ensure that there is legal certainty. Because if the duty actually only concerns the direct commercial partners, then companies are distracted from what they should really do, which is focusing on where the violations actually occur further down the supply chain. And the problem is that if they do not focus on those further supply chains, then they will incur a risk of civil liability because they will not put the efforts that they should put according to the UN guiding principles and OECD guidelines to mitigate the risks further down their supply chains. But nevertheless, those risks will have to be dealt with by the enforcement authority in Germany or in other countries. And that means they will be possibly liable also for the damages that result from these risks. So in Germany, the enforcement authority for the German supply chain law is called the BAFA, and it has pretty broad investigative powers when it is presented with complaints by claimants or by civil society organizations who want to bring to the attention of this administrative authority that there is a pattern of human rights violations in a given situation, but without directly affected persons. And I think the main lesson that we've learned for the last 2.5 years is that for the first time, companies were willing to sit down with the rights holders that were bringing complaints against them. They sat down, they listened to their demands, they went into possible mitigation measures. Some of them actually reacted very quickly by sending officers abroad on the ground to meet with trade unions and come up with contractual clauses. And this brings me to the limitation of this positive lesson learned. Mitigation measures have been mostly limited to shifting the burden of the duty onto suppliers or subcontractors by inserting more and more contractual clauses and by coming up with measures that were not really including the claimants beyond having talked to them 1 or 2 times. So I think this is why we really need to talk about what's the duty, what is the involvement of stakeholders in this duty, and how broad it is, because otherwise the law will just become a fig leaf where claimants meet with companies, but then all the rest excludes them and doesn't help with supporting their realities on the ground.
Thank you, Cannelle. And sort of linked on what you were saying, I remember having a conversation with John Ruggie, the author of the UN Guiding Principles on Business and Human Rights, a few months before his death. And he was voicing concerns in relation to German law and the approach to limit to tier 1 suppliers the due diligence obligations with the exception of the substantiated knowledge criteria, and explaining that this is not in line with international standards. It is not in line with the UN Guiding Principles on Business and Human Rights. And the risks with such an approach is specifically to miss the most severe and the most salient human rights issues for a specific company, because most of the time they happen further down the chain. And then that work of bringing to the attention of the companies the risks then puts a huge burden on civil society and is not really aligned with the idea of companies putting processes in place to become aware of the risk that they cause through their operations, but also throughout the operations of their business partners throughout their supply chains. And I think that's an important point to recall as well. So that leads me to my next question. You already mentioned, you already started to bring in the Omnibus Proposal in your intervention, Cannelle. So maybe turning to Nicolas now to tell us a little bit more concretely, what does the European Commission Omnibus proposes in relation to enforcement mechanisms? So what changes do they propose to make more specifically to the CSDDD on that aspect?
Yes, Claire. The proposal of the Commission, this Omnibus proposal, has several changes regarding enforcement mechanism. I think one was already covered by Cannelle in the sense that the scope, limiting the scope of due diligence to only obliging companies and large companies only to assess the conduct of direct business partners is already a large limitation that will then have impacts and implications for enforcement mechanism under public authorities, but also for the civil liability. So this is one important change, but very particularly on the enforcement mechanism, the main or one change is the suppression of this, it's called like a minimum maximum fine. It means that the rule according to which when a member state introduced a financial fine for not conducting due diligence, the CSDDD is currently drafted, as I mentioned before, have this rule that the fine must be at least 5% of the net turnover of the company. The Commission proposes to delete that cap and to introduce a system in which the Commission will design guidelines regarding the fines that should be given for the violation of due diligence obligations. So that's the first change regarding an enforcement mechanism. The second change regarding this public enforcement mechanism is that the fines should not necessarily be based on the net turnover of the company. So the idea in the CSDDD is that if you're really a large company and making a large turnover, the fine should also be commensurate or based on your profit or on your turnover. So this rule should also be deleted according to the Commission. But I think the very far-reaching change regarding enforcement mechanism is respect to the civil liability provision. So as mentioned before, the civil liability provision aims to oblige member states to modify their tort law in the current CSDDD to ensure that they have a civil liability mechanism in place in domestic law and in private law to ensure that when a company, or at least the large company subject to the CSDDD, fail to conduct their due diligence, which caused a damage, then that they should be held liable. This is the basic idea of the current civil liability provision of the CSDDD. And the main change proposed by the Commission is really to delete basically this provision in Article 29 and replace it by a very vague, and I would dare the word of useless, reminder that member states can in fact put in place regimes of civil liability to hold company liable for damage caused by a failure to comply with the due diligence requirement under the directive. So basically, what does it mean? It could be read in the sense that member states are now, according to this proposal, or would be, according to that proposal, perfectly free to implement or not in their domestic legislation a provision on civil liability. Regarding the civil liability, there is another change. The Commission proposes as well to delete the obligation of member states to ensure reasonable conditions for representative actions by organizations, such as trade unions or environmental obligations. And this has, of course, very important implications because all these cases, transnational cases, usually need a lot of organization and the help of representative organization in the environment or human rights or trade unions to support individual cases sometimes. So this is also a proposal that will have far-reaching implication regarding civil liability.
Thank you so much, Nicolas, for that. And moving to Cannelle now, maybe we start from that second part of Nicolas' intervention, explaining the changes that the Omnibus seeks to bring about in relation to civil liability. And Cannelle, based on your, again, practical experience, can you tell us what are the risks of removing the civil liability provisions in the CSDDD, and in particular, from an access to justice and remedy perspectives, what are the main issues there?
Yes, thank you. I mean, I very much agree with Nicolas on everything that he said. And obviously the risk of removing this and not making it compulsory is that affected people will be left without remedy. And that's a major problem. And so beyond this absence of civil liability in the new Omnibus proposal, also, if we look at the vigilance law in France, for instance, that has a civil liability regime, we have to acknowledge that if such laws do not, or such civil liability mechanism do not include provisions such as reversal of the burden of the proof, or provisions that were in the CSDDD that would alleviate, at the very least, this burden of the proof that lies on the claimants, then we may just as well leave those affected with very little remedy, even when there is a civil mechanism in place, because that is literally ignoring, the structural and very concrete power imbalances and obstacles that are inherent to filing a complaint and seeking remedy abroad against a multinational company that most of the time is in possession of all the information that is needed by a claimant to make their case that, yes, there is not only a violation of the duty of diligence, but also a harm that is caused by this violation of the duty of diligence, which is what, for instance, the French law requires. And so I think what's also very important to mention in relation to civil liability is that, Nicolas has mentioned it, there is also in the Omnibus proposal this limitation of stakeholders who can engage in the process. And if we look at our work in Germany, I mean, the BAFA, this administrative authority, there's two ways of activating it. One is this provision of Hinweise, so an indication, when there is no directly affected person, and that doesn't oblige the administrative authority to take action. And the other way that obliges the authority to take action is when there is someone that can claim is being directly affected by a violation. And in many cases that we worked on, the claimants do not wish or cannot appear as directly affected because of safety reason. I mean, if you are someone affected by state-organized repression in China, you have very good reasons not to be able to be present in such a complaint. And that means if you cannot be represented by civil society organization or by human rights defenders that may represent you, then not only will you not have access to the enforcement authority with all the powers that it has, but also you will not be able to get the support that you need to provide the evidence that is needed in case a civil liability mechanism exists without a reversal of the burden of the proof. And this is really something that we have experienced.
Thank you so much, Cannelle. And I think linked to what you were saying, it's worth reminding that we have studies that show that claimants in this sort of business-related human rights and environmental claims do face many barriers to access justice and remedies, as things are under existing national tort systems. And I co-authored a study for the European Commission specifically on access to legal remedies for victims of corporate human rights abuses in third countries, where we looked at cases that were brought in various member states for alleged human rights and environmental harms that occurred outside of the EU over a period of 10 years. And what we found, first of all, were not many cases were brought because already claimants were facing many barriers to even bringing a case, right, in relation to the cost that it involves, and the lack of knowledge often that they can bring a case also within European jurisdiction. But then when they did manage to bring the case, we found that only 1 or 2 cases actually gave rise to a positive outcome in the substance, and that claimants were facing a whole array of barriers, being procedural, being substantive barriers that I think is really important to overcome. And you were giving some specific examples here from practice, Cannelle, of the ones that are, of some of the barriers that are particularly key for claimants to be able to access justice and legal remedies. And I think it is also worth to remember that it is actually the 3rd pillar of the UN Guiding Principles on Business and Human Rights to ensure that affected individuals and affected communities have access to remedies when they actually get harmed. So it's not a nice to have. It's actually an expectation. It's a legal duty for states, but for companies, it's already an expectation under international standards that the CSDDD refer to as guidance, right? And as the reason, the raison d'être, as we would say, behind the CSDDD, which is to implement international standards. Nicolas, would you like to add something on that?
Oh, I just wanted to agree. I think we all agree that there will be no wave of litigation just because there is a civil liability provision in a mandatory due diligence legislation or in the CSDDD. I think this is very important to remember that the barriers and the costs and the organizational costs are so high that it is already very difficult to bring this kind of cases. But now it is also important to see and understand the very unsatisfactory situation of the proposal of the Omnibus Proposal, letting basically member states decide whether they want to introduce or not such civil liability provision. Because we will have a situation in which in every member state we will have a very clear duty to act or to take several steps to prevent or mitigate a damage, but without a clear result or consequences of a failure to conduct due diligence. And I think that will lead to a situation of great uncertainty for all the parties, for the claimants, the affected individuals, but also the companies that now know that they have a duty to act. And if they cause a damage, of course, every lawyer in each EU member state, whether there is a specific civil liability provision or not, will argue that there was a breach of an obligation that led to a damage. So I think the current situation in which we have now in Article 29 a civil liability provision that is the same for all the EU member states and that is already explaining the conditions, and they are very strict, these conditions of civil liability, is probably the better way to increase legal certainty than letting it to the member states to decide how they want to include or not this liability in their domestic legislation.
Absolutely. And also level the playing field, as you were referring to earlier, Nicolas, which is also very important, and ensuring that all the companies are held to the same standards. And well, so that brings us to the end of our podcast for today. I would like to thank very warmly Cannelle and Nicolas for taking the time to be here and share their insights. I would also like to thank Louis for coordinating the podcast and helping making this happen. And I look forward to seeing you in our next episodes. Stay tuned. Thank you and bye-bye.